My name is Ronnie Conway. I'm the principal lawyer and solicitor advocate at the Conway Accident Law Practice, and I'm grateful for this opportunity to give a brief answer to a question which I'm asked on a routine basis, particularly where people get in touch with me for the first time after an accident. They ask me, Ronnie, I've been in an accident, does that mean I will have to go to court? Now, of course, over here, the public perception of what happens in a court action is based on TV programs such as Kavanagh QC, Defending the Guilty, or God forbid, what we hear from our American cousins such as Ally McBeal, Damages, or CSI. Now, let me assure you, first of all, that those programs where you see poor, helpless, hapless witnesses being skewered by smart-ass lawyers bear no resemblance to reality. In the UK, civil claims are tedious, boring, and of no interest to anyone other than the parties. So even if the worst were to come to the very worst and you had to give evidence, you will find that no one else is interested in it, and counsel will treat you generally with consideration and respect. But to get back to the original question, will I have to go to court? The answer is that it is exceedingly unlikely that you will ever be called upon to take the oath or to affirm. First of all, almost all cases are settled pre-action. And by that I mean there's a set protocol whereby information is exchanged, medical evidence is exchanged, and the case proceeds not against the individual, but against an insurance company. And the insurance company's main interest is to settle the case at the minimum of expense to themselves. To them, you're just a number, preferably nil, and it's nothing personal. It's just the way they are. Their duties are to their shareholders and shareholder value. So they're not interested in racking up legal costs. What they want is to be persuaded that you have a strong case in law. And one of the things that our practice does time and time again is we say to people, it's not what happened to you, it's what you can prove. And we follow that into our own practice by taking action this day steps to obtain and preserve the evidence which we'll be disclosing to the insurance company. Now, at the end of that period, and you're probably talking about 6 to 8 months or so it's not a long time, the insurers have got a choice to make. They either settle, or they repudiate, or perhaps they make an offer that is not enough. If they repudiate, or they make an offer that is not enough, then you've got a choice to make. Do you want to take the case to court? Do you want to go the extra mile to get what might be the true value of your case? Are you prepared to either just forget about it or to accept a cut price settlement? And we will put that to you in straightforward terms. Now, the next point is that I indicated to you that insurers are looking to minimise their exposure at every turn of the coin, really. That they kind of try you out at this point in time because they know that people don't want to go to court, they know that people don't want hassle, they know that people just want to put things behind themselves. So almost inevitably, the offer, if there is an offer, is a discounted offer. The advantage that our case preparation gives you is that you can then make a proper and informed choice as to what you want to do. What happens if your case goes to court? All that means is that proceedings have been raised, and the likelihood of you ever having to go to court in the sense of a court hearing is very, very slim. The research was done which showed that 98% of cases settled. If you ask me directly, Am I going to have to go to court? I cannot give you a guarantee that you won't go to court, but the chances are it's exceedingly unlikely. The chances are very, very slim. I've written a book which is called the Scotland Accident and Injury Advice Book, How to Avoid the Mistakes That Can Often Ruin Your Personal Injury Claim. It's available on Amazon, but it's also available free hard copy on request if you get in touch with us at our website. If you fill in an online inquiry form, we can send it to you hard copy, or you can download it as a PDF. If you've been affected or are interested in any of the issues that we've discussed here, please get in touch with us. You can do so either by completing the online inquiry form or by telephoning us. We're ready to listen to you. We're ready to help you.